Hello and welcome to Viewpoint. I'm Volodymyr Solohub. Joining me now to discuss the legal significance of events happening in eastern Ukraine is the Associate Professor at the Department of Criminal Law and Criminology of Moscow State University, Mr. Gleb Bogush. Mr. Bogush, welcome to Viewpoint.
Thank you.
Mr. Bogush, for more than a year and a half now, eastern part of Ukraine is engulfed in a full-fledged war. And the Ukrainian government refuses to recognize it as a war, refuses to declare a war. It refers to the events happening in eastern Ukraine as anti-terrorist operation. But from the standpoint of international humanitarian law, can you tell us what is happening there?
From the viewpoint of international law, an armed conflict is taking place. You're right that the Ukrainian government is reluctant to use this war and even armed conflict regarding the situation in eastern Ukraine. However, it's absolutely obvious from the available evidence that an armed conflict is taking place, the scale of military operation, the control of the separatist forces over the territory in eastern regions of Ukraine leaves no doubt that there is an armed conflict, as it's more correctly characterized by international humanitarian law.
Mr. Bogush, in the international humanitarian law, there is a distinction between international armed conflict and non-international armed conflict, if I'm correct. So how would you describe what is happening there?
Absolutely right. There is a distinction that matters when it comes to the status of the parties of the conflict and the scope of the applicable rules of international humanitarian law. However, the core of the principles of this branch of international law, law of the armed conflict, is applicable to both types of conflict. Regarding the eastern Ukraine, there is the allegations mostly from Ukrainian side and also from some other states that there is an involvement of the third state of the Russian Federation to the conflict. The practice of the international criminal tribunals and also the doctrine of international law suggests that to become international in such situation, there are two options of internationalization of the armed conflict. First is the actual presence and participation of the regular armed forces of the third state, and the second option is the control, so-called overall control of the third state over the insurgents. However, the best way to deal with such legal notions is the judicial scrutiny, the proceedings before international courts.
But what is, again, from the legal standpoint, what is the legal significance of the armed conflict being recognized as international armed conflict?
The first, from the point of international humanitarian law, the crucial difference is that all Geneva Conventions, rules of the Geneva Conventions are applicable to this situation. It means, for example,
to the international or non-international armed conflict?
To international armed conflict, because Geneva Convention as such are applicable only in international armed conflict, for the exception of the common Article 3 that sets out some core principles and prohibitions, restrictions for the armed hostilities.
And Mr. Bogush, you just said that there are two options of defining this armed conflict as international, is where a third state has a presence of its regular forces, which Russian Federation is denying at all times, or the other option is to recognize that the third state has control over the militants who are operating in eastern Ukraine. Does the fact that Russia Russia numerously confirmed that they are supporting this movement in eastern Ukraine, that Russian citizens are present there, can this amount to the control over the militants?
Not automatically. The presence of the citizens and even some members of the armed forces, the mere presence of them, doesn't amount to the internationalization of the conflict automatically. Even this control requirement, which is rather rather vague and depends on the various criteria. The various criteria is not so certain when it comes to the so-called hybrid military operation. So it's to complicate matters. There can be coexistence of the two armed conflicts, international and non-international. However, what is important in terms of the protection of the victims and criminal investigations of the crimes committed during the armed conflict is that both types of conflict have the same core of applicable rules, and specifically the rules prohibiting the war crimes. That is very important in terms of the upcoming investigation of the International Criminal Court.
So basically, regardless whether this conflict is recognized as international or non-international, the core principles regarding the rules of war, they do apply there.
Yes.
So can you tell what are the main rules which do apply there, and whether the militants who are operating in Eastern Ukraine are bound by these rules?
The core rules concern the protection of the victims of war. First of all, civilians, prisoners of war, but the category of prisoners of war also applicable only to international armed conflict. However, there is also rules that protecting the fair trial rights and other rights that prohibit the torture, inhumane treatment of the participants of the conflict.
What about the rights of prisoners of war? Do they apply there? Because the way we refer to them is the prisoners, POVs, prisoners of war. And since there is no war, a lot of people ask the question whether the Ukrainian, basically the members of the Ukrainian military who are being captured by the other side, what kind of rights are they granted?
They are granted by the basic rights, including the humane treatment, and it's prohibited to. There are the clear prohibitions of outrages of personal dignity, the fair trial rights, and there is unfortunately the evidence of the inhumane treatment and torture and even summary executions. It's actually very troubling in terms of this conflict. However, regarding the militants, regarding the participants, because we call them differently, but there is no doubt that they are bound by the rules of the armed conflict. The rules of armed conflict, including the prohibitions, are applied equally to the parties. That is one of the main principles of international humanitarian law, and the same applies to violations. The fact that one party violates the rules of international criminal law doesn't free the other party from following these rules.
Do you think that the militants in eastern Ukraine who are fighting against the Ukrainian army, and you just said that there is already evidence of them committing war crimes like summary executions and torture, inhumane treatment, they can be brought to justice? And if so, who can do that?
I would prefer to talk about the responsibility of persons responsible for violation of international humanitarian law. It's very important in the conflict like this not to talk about one party, regardless the scope of evidence that we have. It sends basically the wrong message to international community, to the other states, and shows that the state is targeting only one party. That's a wrong message. When it comes to the responsibility, there are different options, different ways of dealing with the war crimes. Normally, what is mostly referred regarding this situation is the option of prosecution in the International Criminal Court. However, International Criminal Court has limited capacity. It is a court of last resort that is based on principle of complementarity. It supplements the national systems of criminal justice. Apart from national criminal justice system, there are also option of so-called hybrid tribunals. There are options of the fact-finding commission. That this is the first step actually in conducting the investigations on the crimes of war. And I think that we should not focus only on one option. But of course, the investigation in International Criminal Court, in my view, is crucially important, because the conflict in Eastern Ukraine is one of those situations for which International Criminal Court was created. Moreover, the Ukrainian government, Ukrainian state, specifically referred this situation. They recognize a jurisdiction regarding this situation. It shows that Ukrainian government, regardless of legal qualification of the situation, considers de facto is as an armed conflict, and it calls for international justice to assist these efforts to bring in these perpetrators to justice.
You're right about the International Criminal Court. Ukraine has accepted its jurisdiction on its territory for all events which are happening, have been happening since February the 20th, 2014. But from the practical standpoint, do you think that ICC will be, first of all, whether they will accept this case, and secondly, whether they will be effective in bringing those who are responsible for war crimes to justice?
Yes, I already mentioned that the situation in Ukraine is a kind of perfect situation or perfect case. Of course, it's a bit cynical characterization, but anyway, it satisfied all criteria for investigation of International Criminal Court. When we compare it with the most recent decision on Georgian situation, the armed conflict in South Ossetia in 2008. Ukrainian conflict presents much more strong criteria for the ICC, for the ICC's investigation. It warrants actually ICC investigation. However, the prosecutor has a broad discretion to begin investigation, and I think that it depends on the several criteria, including the efforts of Ukrainian justice system, the ratification of the Rome Statute by Ukraine, because the statute has not been ratified yet. We heard about this 3 years delay in dealing with the ratification process, and I also think that it's also sending a wrong message, because the ICC can wait as well. And I think that the court has some reasons to wait, because the declaration, the content of the declaration of accepting the jurisdiction, and actually the situation with available evidence directly shows only to Ukrainian state. It shows that, demonstrate that only Ukrainian, the evidence provided by the Ukrainian state should be available for the court. It, of course, makes the situation undesirable for the ICC, because the ICC, the main principle that the law applies equally to all parties, and situation includes the crimes committed by both parties of the conflict. So it's very important to focus on the genuine efforts and create the climate of the accountability. And that is crucially important. And this ratification process should be, I think it should be speeded up. And I don't think that this delay serves the interest of justice.
Looks like some big intricacies in international law. Mr. Bogush, unfortunately our time is running up. Thank you very much for joining us today. We were discussing the application of the rules of war to the events in eastern Ukraine with the Associate Professor at the Department of Criminal Law and Criminology of Moscow State University, Mr. Gleb Bogush. I'm Volodymyr. Thank you for watching Viewpoint.